Thank you very much. Good morning, Senator Coons, Ranking Member Senator Sessions, and Senator Grassley. On behalf of the United States District Court for the District of Delaware, I thank you for the opportunity to appear before the committee today to share with you some information about the court in relation to the Federal Judgeship Act of 2013. And because my time is limited, I'll skip my wonderful story about Judge Roth and move on, so hopefully you'll read the statement. Let me step back. The District of Delaware has had 4 judges since 1985, although we had a vacancy for almost 4 years from 2006 to 2010. In the year 1991, when I first came on the bench, 37 patent cases were filed in the District of Delaware, about 9 cases per judge. At that time, even 9 patent cases was not an insignificant number of cases per judge. With the exception of 1 year, since the year 2000, the District of Delaware has been among the top 5 districts in the country in terms of the raw numbers of patent cases filed, and has had more patent cases per judgeship than any other district. As of August 31, 2013, there have been 1,394 patent cases filed in the District of Delaware so far in the fiscal year 2013. The patent filings per authorized judgeship using completed fiscal year 2012 was 202 patent filings per judge. And you can see how that number compares to other high-volume courts in the graphs that accompanied my statement. In terms of the statistic that the Judicial Conference of the United States uses to justify the authorization, the current national standard of weighted filings per judgeship is 500 cases. The District of Delaware has 1,812 weighted filings per judgeship, exceeding the national standard by Federal Times. But it is more than the sheer number of cases that makes our need for the 5th judgeship such a compelling one. Whether you characterize the magnitude of the caseload pre-AIA or post-AIA, the complexity of the mechanics to resolve these cases is the same. In other words, whether you have 10 defendants in one case or 10 cases each with a single defendant, the process starts with motions to dismiss. It goes on to a discovery practice, which is the part of the process I believe subject to the most abuse by the bar and would benefit most from the supervision of the court. When the parties have completed discovery, the next steps in a patent case typically include claim construction, a requirement unlike any found in other civil cases, and the submission of summary judgment motions. If there are issues left to be tried at the conclusion of this motion practice, you as a judge have to decide motions in limine and conduct the bench or jury trial with the evidentiary disputes that inevitably arise during trial. Your final responsibility is to review the dispute yet again post-trial, and just when you think you've fulfilled your responsibilities as a trial judge, the case is appealed and the Federal Circuit may remand the case back for further proceedings. And in Delaware, the judges go through this process continually, always with the overlay of technology inherent in patent litigation, whether you're dealing with chemical patents or software patents. Clearly, the mechanics of a patent case are complex and burdensome, and the court's resources to manage the case will never equal the resources of the parties to litigate the case. And in just one of my patent cases tried in this fiscal year with a single plaintiff, a single defendant, and 10 patents at issue, the parties filed 13 dispositive motions accompanied by 782 pages of briefing, with over 8,500 pages of appendices, 8 boxes of trial exhibits, and with at least 46 lawyers involved in the litigation. And of course, besides the patent litigation, we also have our criminal caseload and our other civil docket that we need to follow. So for judges like me who've been on the bench for decades, I can't really quantify for you the workload associated with the caseload, except that I have 2 law clerks versus the 46 lawyers in a typical patent case. I take my responsibilities as a trial judge seriously, as do my colleagues. We have taken an oath to give every party in our court due process, regardless of who the party is, And ensuring due process means giving every party a fair and reasonable opportunity to demonstrate the merits of its allegations. So long as the Patent and Trademark Office continues to issue patents that have the potential for impacting the market, there will continue to be business disputes over the metes and bounds of the monopolies associated with those patents. It is both a privilege and a weighty responsibility to help the parties resolve those disputes, but the court cannot do so without sufficient resources. Due process, not the numbers, is what's driving our request for a fifth judge. Thank you for your kind attention.